Good afternoon, everyone. My name is Mark Rotenberg. I'm an adjunct professor here at Georgetown University Law Center and executive director of the Electronic Privacy Information Center in Washington, D.C. It's my pleasure today to welcome you to a panel discussion on emerging privacy issues, exploring the transatlantic gap. We are considering today the perspectives on privacy in the United States and the European Union, and we're very pleased to be joined by members of the European Parliament who serve on the Committee on Civil Liberties and Justice and Home Affairs. In a moment, I'll introduce our panelists, give them a few moments to speak. We'll have a discussion, and then we'll open it up. I would like to begin by thanking Georgetown University Law Center for making this event possible, and to thank also Dean Olenikoff, Professor Julie Cohen, and also Pablo Molina, the Chief Information Officer for Georgetown, who's actually done a great deal of work to try to promote transatlantic discussion on emerging data protection issues. So thank you all for your help. Our speakers today include Sophie Intveld. She is from the Netherlands. She is the rapporteur on the passenger name record agreement. Baroness Sarah Ludford from the United Kingdom. She also serves on the Committee on Foreign Affairs, and she is the rapporteur on visa-related issues. Mr. Alexander Alvaro from Germany. He is the former rapporteur on data retention. And I'm sorry, I've got another person on the panel here. This is Mr. Ignacy Guardans from Spain, the vice chairman on the Committee on International Trade. And here at Georgetown University Law Center, Professor Adam Levitin. Professor Levitin is a specialist in commercial law, finance, and identity theft and security breach legislation. So thank you all for your participation.
I think it's a bit different in the UK. I'm not aware, really, of any popular concern about data collection by private companies. Not certainly in the popular press. But in contrast, there is a lot of concern about collection by the government. There's a perception that our government, and okay, I'll be a little bit party political here, is at least soft authoritarian, if not hard authoritarian. And we've never had identity cards. Well, we did. We had them during the Second World War, and they were abolished shortly afterwards. And there is it's something of a sort of badge of identity for a true-born Englishman that doesn't have to tell anybody who he is, as it were. And so the present government's proposal to reintroduce identity cards has got about 50% of the population opposed to it in opinion polls. But and also we've had spectacular losses of data by government agencies, like 25 million people's personal records by the tax authorities. This was for a welfare benefit onto unencrypted disks, and quite a lot of other. In fact, you're hearing more about them. You probably would hear even more if there was a statutory obligation to notify security breaches, because we don't hear about all of them. So that is very much in the public in public debate. Is what is government, that you can't trust government with your data, either because they'll abuse it or because they'll lose it. But not really, I don't think about the private
It's a mentality issue because, again, the agencies, the Data Protection Agency, for example, in Spain, it has imposed, at European level also, but at least in Spain, it has imposed several huge fines to companies, to Telefonica, to other companies which have not telecoms, just for mismanagement of data, of private data. And people know that, people are aware of that, and people are trusting that agency. And the same way they trust the state. I will give you an example, which I'm not sure whether that would be the case, or it is the case, perhaps I'm wrong, in the UK or even here. When the moment to pay the income tax comes, everybody in Spain receives at home an envelope with all the information the tax authorities have about you. about what that fiscal year, what you have done, what you have earned here and there. In my case, for example, I give a lecture here, I get paid for this thing, the other thing, besides, and it's like your profile. It's your profile. You have a whole paper of everything, every single penny you have earned under any circumstance. And then if you accept it as a fair statement, then you just sign it, and that you pay taxes on the basis of that. If you don't, if you think there's a mistake in that, which sometimes it's the case, it includes information provided by banks. What's in your bank account? What's the average or whatever. If you don't agree with that, then you file a form, you fill a form, and then that's your tax declaration. Nobody's scared about that, as long as it is the state. But anything about, I insist, on Google, on any company, any advertising company, is seen as something that it is an attack, a direct attack on your own
privacy. Can I give you one, if you allow me, one concrete example of why we cannot sort of dissociate these two? The Dutch tax authorities now, and this became public only a month ago or so, what they are doing is they compare somebody's tax declaration to information they get on the internet, social networks, and they Google a person, and then they compare, saying, well, you say you were working in this country, but you know you're meeting people in this other country. I mean, they're using that information.
Well, one of the very interesting opportunities, I mean, the members of the European Parliament have, of course, is to craft law to respond to some of these new challenges. And I wanted to turn to an area that's been of considerable concern, I think, both in the United States and the European Union in the last few years, and that's the problem of security breaches. We've certainly experienced in the United States and government agencies and the private sector and universities the loss of personal data, which has led to, many people believe, growing instances of identity theft, although it's oftentimes been difficult to show the causal connection. I think it was established, in fact, in the Choice Point case. That was the case where large data brokers sold information on American consumers to a criminal ring engaged in identity theft, and so there the connection was clearly established. But sometimes it's not so easy. Maybe Professor Levitin can tell us a little bit about the current state of play with respect to security breach legislation in the U.S. I know that similar proposals are under consideration in the U.K., and maybe this is an area that the Parliament might act. But is this, what is your view of the U.S. experience? Has this been an effective approach? What else would you do if you were drafting a law? What things would you think about?
Well, for starters, I'd say it's not well, why don't I start by laying out what the field looks like in the U.S.
Thank you.
We do not have any federal legislation on data security breaches. Instead, it primarily exists on the state level. So 33 states, at my last count, have some sort of data security breach legislation. New York City also has its own legislation, but that is preempted by New York State's law. And then there's also some self-regulatory and contractual arrangements, but trying to keep track of that is very difficult because it operates outside of sort of the public view. These laws vary in what they do, but most of them follow the model of California, which was the first state to enact them in, I think, 2003. And generally, they're pretty broad disclosure requirements that if there is any unauthorized access, or sometimes even the possibility of unauthorized access to consumer data, the company whose data security has been breached has an obligation to notify any of the affected consumers. And often it's hard to know, well, what records were actually accessed. This could be potentially thousands or hundreds of thousands or millions of consumers, and not just consumers in the United States, but consumers all over the world. If you consider what the cost of a single notification, notifying a single consumer, that's probably a couple dollars between paper, postage, printing, so forth, overhead costs. They can be a tremendous cost on a company to do such a notification, and it's not clear that it really has many benefits. So the theory behind the notification legislation is twofold. First, the thought is to impose a reputational sanction on the company, that if your company is not good at protecting its data, and that gets out to the market, well, the consumers may want to go and do business with one of your competitors instead. That all supposes that consumers pay attention to this and care. And I think outside of the financial institution context, there's not a lot of reason to think that consumers really care about this, or at least care about it enough to change who they do business with. It doesn't shift the balance of competitive decision making. The second factor, sort of reason for having these laws, was to enable consumers whose data has been compromised or potentially compromised to mitigate the harm. And the thought is, well, they can't mitigate unless they actually know that there's a potential problem. The danger, however, is that these laws are written so broadly that consumers could end up with too many notifications. And if consumers get hundreds of notifications a year, they may stop paying attention to any of them. This is sort of the boy who cried wolf problem, that many data security breaches do not actually lead to any sort of identity theft, or at least no one's able to connect an identity theft problem to a specific data security breach. So how valuable are these laws? They seem to be a lot more, I think, about show than about actual impact. That it's a way for members and state legislatures to get up and say, we're really trying to work on data privacy and consumer protection issues without having to take real onerous steps. Instead, what seems to be maybe more effective are, at least on the identity theft front, our credit bureau report freeze laws. So a number of states have started enacting laws that allow consumers to freeze their data at consumer credit reporting bureaus. And that is kind of a linchpin within your data at a credit reporting bureau is sort of a linchpin within the consumer credit system. That a credit card company is not going to issue you a credit card, or a mortgage broker isn't going to make you a mortgage loan without first checking your credit score. And your credit score is going to depend on what sort of data is around within your credit report kept by there are three major private credit reporting agencies, a number of smaller ones. If you're able to place a freeze on these accounts, it means no new accounts can be opened. And your score depends in part on how many lines of credit you have out there. So if you have a freeze, then the fraudster can't come along and open up an account in your name, even if the person has enough personal information about you to essentially replicate your identity. So that may be the more effective way we do it. I should say, I mentioned we don't have federal law on this. That's not entirely true. Sarbanes-Oxley has a provision. Section 404 of Sarbanes-Oxley requires public companies to disclose any unauthorized use of company assets that would have a material financial impact on the company. Whether that means that's going to mean that some data security breaches will get reported because of Sarbanes-Oxley, but many may not. The company may decide it's not material. Certainly, if they don't have a state reporting requirement that they're subject to, it would not be material. I think it would be hard to find materiality. And then we also have the choice point case raises another way that we have gotten federal law in the area, kind of through the back door. Namely, the FTC, through consent agreements, has been able to essentially set a standard for the data brokerage industry. That by the choice point settlement, one can see it as imposing a standard of taking reasonable security precautions for data brokers. Of course, that's not binding federal law. That's just the FTC settling with one party. But it sets a standard that other companies probably are going to try and follow, is my guess.
All right, well, thank you. And just, if I may clarify, when you say credit freeze, you're really sort of talking about moving from the opt-out to the opt-in in terms of the disclosure of the credit report, right?
Well, it's not whether it's not whether someone can get your credit report. Right. It's whether a new account can be opened And the Credit Reporting Bureau...
But you would have to initiate it. In other words,
Exactly.
you'd have to make an affirmative decision once that freeze is in place to not release the information to someone else.
No, you'd have to make an affirmative decision to unfreeze the account, the credit reporting account, to allow a new account to be opened.
Right.
In that way. It's not about access to the report.
Right.
It's about whether the contents of the report can be changed.
We're going to need to wrap up in a moment, but let me ask Professor Levitin, you've heard quite a discussion this afternoon. If you had a couple of recommendations on the policy front, what would they be?
Whatever rights you create, make sure that they have a very viable method of vindication. That a general problem, and I'm sure it goes far beyond U.S. law, but a problem we often see in U.S. law is the creation of rights that cannot easily be vindicated, or when either that the parties who can bring an enforcement action are limited, and will often maybe it'll be limited to certain government agencies, and depending on the administration, will or will not bring actions. And then even when actions can be brought, making sure that the penalties are sufficient to deter. So, I mean, if you think of this in the data security breach context, does the punishment outweigh the cost of taking care? If the punishment is less than the cost of taking care, why bother to take care? And I wonder if that's the situation we're in right now. And then then when we're looking at sort of the government's use of data, we can kind of think of maybe two different metrics. One is how politically responsive government is in its uses. So one of the concerns we see right now with Homeland Security now is that there's a sense that the current administration is really not very politically responsive on any of its decisions, that it makes a decision and doesn't care what the political consequences are. And by the same token, I think there's a metric of, well, what's the benefit? Generally, we think of government use of data. It should have a public benefit. And that might be why, as Ignacy was saying, we are often more comfortable with government having data than with a private company having data. But when we see a lack of competence in sort of a no-fly list that is both too broad and yet also probably misses a lot of people, we have to wonder if there's any benefit. So I think maybe setting up a system that can easily be monitored and recalibrated, both by in terms of political responsibility, but have a sort of a metric of benefits that can be evaluated periodically, might be one thing to think about.
Well, those are all excellent suggestions. Thank you very much. And I'd especially like to thank our panelists who took some time out of a series of meetings on Capitol Hill and with members of the Federal Trade Commission to come to Georgetown Law Center and to meet with us and talk about the emerging privacy challenges and some of the efforts to bridge the Atlantic divide. So thank you very much for being with us.
Thank you.